Hello and welcome to the Briefing Room. I'm Bill Froehlich, and this is our weekly roundup. A look at some of the stories that have been making headlines across northern Michigan. And we've really literally got it laid out on the table here before us today, and we're joined by Eric VanDussen from Benzie County. Eric, thanks for coming in.
No problem.
Good to have you with us.
Glad to be here.
Professionally, during the work week, you work for a local attorney, correct?
Correct. I work for attorney Jesse Williams. He primarily practices in the criminal law and criminal defense. We do some civil work, but probably 90% of his practice is criminal defense.
You have also kind of become known as a freelance journalist. I don't know what writings or publications you've done, but really kind of keeping your eye on some of the local happenings that have made the news over the past 10 or 15 years has been something that you've always done, right?
Correct. I mean, I've been doing freelance journalism for probably over 20 years, but ultimately for the last probably 5 years, I've been working pretty closely with Jesse Williams. I started out part-time while I was still doing freelance, and it morphed into working full-time for him, basically because freelance journalism doesn't pay enough to survive on,
right.
As you, I'm sure, know.
I'm aware of that, yes, in fact. Well, you're not necessarily a true, full-time journalist in that sense of the word, but really what you've been working on lately is coming up all over the news here in Traverse City in the Record Eagle, and I've got in front of me here last Friday's edition, February the 19th. The front page story and the little sidebar piece refers to you specifically, Eric. And then Thursday, today, as we sit down on February the 25th, another front page story. And I was thinking as I drove in this morning, too, that really on this program, we don't spend a lot of time talking about Benzie County, but you certainly are paying a lot of attention, and rightfully so. I mean, there are things happening in Benzie County that deserve some more attention, and I presume that's kind of why you dove into this mess.
Well, I think primarily it's because I live there, and I'm affected by what is going on.
Sure.
And when something comes to my attention that piques my interest, the way my mind works is I nitpick stuff apart and look at the legalities of it. So when I see things such as I read through the minutes of board meetings of different townships and the county boards and county board committees, and I see things that I know to a certainty are violative of open government laws, such as the Freedom of Information Act or the Open Meetings Act, that it really irks me. And
sure.
I think that the real disturbing trend is that I see these public bodies receiving absurd advice from their own attorneys with regards to these legal issues, to the point where it borders on malpractice by their attorneys, in my opinion.
Well, we're going to have to obviously get into the weeds here of what we're talking about so everybody watching can follow along, but we're really focused on the Benzie County Sheriff's Office and the firing of, or not the firing, but the departure of Under Sheriff David Tucker.
Correct.
And presumably at some point, correct me if you have a different understanding, but presumably at some point in history, Sheriff Ted Schendel and Under Sheriff David Tucker got along. They were friends. Tucker became the Under Sheriff for Ted Schendel, and if there was some animosity there from the beginning, my take on it is that probably wouldn't have happened in the first place. But at some point, obviously, that relationship deteriorated.
Well, absolutely. If you look at the history, then Sergeant Tucker was added onto the ticket to run with Schendel as his undersheriff during the last sheriff's election. This is an election year again, and Sheriff Schendel is once again running for re-election. And obviously, as a reporter, you couldn't report the rumor mill, which is that David Tucker intended to run against Sheriff Schendel in this election. And it's my understanding that Mr. Tucker has picked up petitions and is currently gathering signatures to be included on the Republican primary ballot for this year's election running against Sheriff Schendel. And I'm not sure if that's where the animosity started because of Sheriff Schindel becoming aware that that was going to occur, and that's what initiated the investigation of Sergeant Tucker for allegedly working at cherry growers while he was supposed to be working as undersheriff. And the validity of those claims was thoroughly investigated by the Michigan State Police. I think around March of last year, about a year ago. And ultimately, I think in April of last year, the special prosecutor that was assigned to review that from Leelanau County, Joe Hubble, I believe it was either him or Donaldson, his assistant, reviewed the reports and indicated that they would not be seeking charges against him. They're not authorized charges against David Tucker because they didn't find any wrongdoing on his part.
The assertion was that, as you said, Tucker was working one job while he was supposed to be working at the sheriff's office, and there was a question about whether time cards were altered or falsified.
Correct, and ultimately those allegations didn't merit a prosecution in the eyes of the special prosecutor that was appointed to that. And around that same time in April, the sheriff placed, when the investigation was going on, I'm not certain about the exact dates,
sure,
but Tucker initially was placed on paid administrative leave, and then at some point he was placed on unpaid leave. And after the investigation concluded, the sheriff had, I guess I have to jump back, when Sheriff Schindel agreed to allow Tucker to be his running mate and enter in the undersheriff position, he signed a contract with David Tucker that was, from what I've seen of the exhibits in Tucker's recent lawsuit, it demonstrates that the county also signed on to a contract that would permit David Tucker to go back to his patrol union if he was terminated from the undersheriff position by the sheriff, or if he resigned that position, he would automatically go back to the road patrol union. And
where he was before, right?
Well, I'm not sure if he was entitled to go back to his sergeant position, but he would be entitled to go back to the road patrol union and be under that union protection umbrella. Yep. And when that didn't occur, it's my understanding that David Tucker filed a grievance with the sheriff under the protections of under the union procedures. And after the sheriff did not follow through with responding to his grievances per the union contract, Mr. Tucker filed an appeal with the Human Resource Committee of the Benzie County Board of Commissioners. It's a 3-person committee that is the next step in the grievance procedure. So then they started reviewing his grievance at that time.
So now we're summer of last year at this point.
In July of 2015, July 28th of 2015, the HR committee met and indicated that they would hear the appeal grievance, that they would themselves hear the appeal grievance. They have a procedure where the county administrator they could task that to just the county administrator to unilaterally deal with a grievance appeal that's filed by someone in the union at the sheriff's department. They decided in July that they would take that upon themselves to do that, and then I'm finding out recently that there's documentation that shows they went into a closed session with David Tucker on August 31st of 2015 without any public notice. The sheriff was not aware. He told me at the last board meeting, the sheriff did, that he was not aware that that meeting occurred, or he would have been there. And the HR committee had that closed session that, in my opinion, had no proper purpose. It wasn't a proper purpose under the Open Meetings Act to go into that closed session, and the HR committee did not provide proper public notice as outlined in the Open Meetings Act to conduct a meeting in the first place. So that's when they held that closed session with David Tucker, and out of that closed session, they made a resolution to give him a payoff for the amount of money that he was claiming he was due when he was off on unpaid leave during that period of time when the sheriff had him on unpaid leave. And ultimately, after he was on unpaid leave for a while, he decided to retire. So Tucker retired from the sheriff's office for financial reasons. He's saying he was forced to retire because of financial reasons, because he already had his 25 years in, and he was entitled to retire at that point.
Man, that only gets us through the fall, man. It doesn't even get us through the headlines in the paper here the last a week or so. Ultimately, the county commissioners kind of became aware of this idea that Tucker was going to be filing a lawsuit against the county, and so they also went into a closed session, and really that's kind of where you step in and request some documentation under the Freedom of Information Act, right?
Correct. And to keep the timeline going here, subsequent to, I filed my Open Meeting Act and Freedom of Information Act lawsuit on February 1st, and subsequent to that, there are people that are providing me with more information that has caused me to, and my attorney, who's Froehlich Nielsen, to view these documents as additional violations of the Open Meetings Act. Like, we were not aware of the August 31st HR committee meeting at the time I initially filed my lawsuit, and we've become aware of that subsequently, so we're adding an additional count and other counts to my lawsuit pertaining to those and a couple other issues. But what also I found out is that in November of 2015, a draft proposed complaint was submitted to the county's attorneys, Cole, Stoker, and Toski, that law firm, and ultimately ended up in the hands of the county administrator, our new county administrator, Mitch, I forget his last name, I'm sorry. And when that ended up in his hands, per our county's liability insurance policy, Michigan Municipal Risk Management Authority, that contract with the county compels the county, when anyone threatens to sue the county or actually does sue the county, they have to submit any documents pertaining to that to the risk insurer for a determination on whether or not it falls under the coverage. And that was done in November. And so after that was done, then some negotiations behind the scenes were still ongoing with David Tucker and the county's attorneys regarding the threat of litigation. So it moved from a grievance and a settlement that was offered to Tucker by the HR committee that ultimately, I believe, was rejected by Sergeant Tucker. And then it moved to the threat of litigation, the threat of filing a federal lawsuit, and that was in November. And then December 22nd, 2015, the Board of Commissioners votes to go into a closed session to discuss legal issues with their legal counsel.
Something vague at that time, we didn't know specifically what.
To discuss legal issues with legal counsel Bonnie Toski, who's with Cole, Stoker, and Toski. And what I'm finding out now is that the Michigan MMRMA, the county's insurer, had already assigned a different firm, Cummins, McClory, Davis, and Acho, to represent the county in that threat of litigation that Tucker had, Tucker's attorneys had submitted to the county.
Okay.
So the county then goes into, on December 22nd, with an attorney that is not even representing them regarding that threat of litigation, because MMRMA had already assigned other counsel, Cummins, McClory, Davis, and Acho, specifically Alan Vanderlaan, who works with them, to address that issue.
Not to mention, but we're going to mention, the fact that because it's just the threat of or pending litigation and not actual litigation, that fact alone should prevent a closed session, shouldn't it?
You know, that's That's my allegations in my lawsuit, absolutely. Under the Open Meetings Act, you can go into closed session to discuss specific pending litigation, but only if it will have a detrimental financial effect on your litigating position. The other Open Meeting Act exemption that could potentially apply to such a closed session is the one that allows, it's not a specified Open Meeting Act exemption, but there's a catch-all in the Open Meetings Act that allows you to go into closed session to discuss things that are protected by some other statutes that would entitle you to confidentiality, such as the attorney-client privilege. So if an attorney, it has to be a written opinion from an attorney. You can go, a public body can go into closed session to discuss a written opinion and written legal advice from an attorney, which it is my understanding that the law firm of Cole, Stoker, and Tosky wrote a legal memorandum regarding Tucker's threat of litigation that was dated December 16th of 2015 that was being discussed in that closed session, even though another attorney had been assigned to that issue before the closed session.
Right.
And, you know, I really don't understand how the Board of Commissioners, you know, I have a memo from September 2nd and another memo, some emails that indicate that the board was fully aware prior to that closed session, and the county administrator was aware prior to that closed session that another attorney was representing them in that threat of litigation. So for them to say that they're going to a closed session with an attorney that's not even representing them on that issue any longer, I don't get that. I don't understand the rationale of that.
Well, and that just makes me wonder if billable hours ensued with that attorney that they met with in closed session.
Well, they have a contract with that firm, you know, a retainer agreement with them, but it does, you know, they still are counting their hours towards that ultimate retainer. You know, there's a limited amount of hours in that retainer agreement. If it goes beyond that, then obviously the county's going to have to pay more money to that law firm.
So that brought you to what? You said February when you filed your complaint, and trying to get into the weeds of what that closed session was about.
Well, initially, right after the December 22nd closed session, I filed 2 Freedom of Information Act requests shortly thereafter, and the Freedom of Information Acts were intentionally drafted very broadly, and you know, I'm paraphrasing, but they ultimately requested all public records, emails, invoices, documents pertaining to the issues that were discussed during that December 22nd closed session. Because, like getting back to our initial discussion, that's the way my mind works. If I see minutes, you know, the county clerk Dawn Alney, you know, if I don't make a meeting, she emails not just to me, but draft minutes of anyone on her list that requests them. She'll send draft copies of the meeting minutes. And when I opened those and read that, I'm like, they're trying to be secretive. And that's the first thing, that was the catalyst for all of this, was reading in their minutes that they went into closed session. And when they go into closed session, you know, this isn't my first rodeo. I've been suing Benzie County and the Sheriff's Department for violating the Open Meetings Act and the Freedom of Information Act going back to 2000. And I've probably filed 6 or 7 of those type of lawsuits against the Sheriff's Department and the county regarding those Open Meeting Act laws. So when I see that in the minutes, it piques my interest, and then I am reading that that's not a permissible purpose to go into that closed session. You know, it's not actual specific pending litigation, and they're not stating in their open meeting minutes the actual purpose for going into closed session. You know, so
which they also should be doing.
Absolutely. So I submit those FOIA requests, and those FOIA are wholly denied by the county FOIA coordinator and the sheriff's FOIA coordinator. So I shortly thereafter, after receiving those denials, filed FOIA appeals. Now, under the FOIA, you have 2 options when you're given a denial from a public body. You can either sue them in circuit court immediately, or you can file an appeal to the head of the public body, which in the case of the commissioners, I'm appealing to them. They sit as an appellate body over the initial determination, which was a denial of their FOIA coordinator. As far as the sheriff, he's his own public body. He's a unilateral public body because he's an executive elected official. So I appealed his FOIA coordinator denial to him. And Cole Stoker-Toski and attorney Richard Figuera both looked at my FOIA appeals, and they were written as legal briefs, you know, in preparation for my lawsuit. I'm like, you know, it's like a shot over their bow saying, look, these are everything we just discussed about whether or not they went into closed session illegally and whether those documents are subject to disclosure under FOIA. You know, they have a duty to provide me anything that is not exemptable under the FOIA. And their responses were so preposterous. I mean, their argument is that anything we discussed in closed session, any documents pertaining to what we discussed in closed session, are subject to the attorney-client privilege, and you can't get those under FOIA because they're subject to attorney-client privilege. Well, their attorneys full well know, at least should full well know, or they're incompetent. They should know that the FOIA imposes a duty upon public bodies to separate exempt information from non-exempt information. So going back to that, just one document, the one that they admitted, one out of the pile that they admitted was relevant to my FOIA request, in my FOIA appeal, they said there's that's when they acknowledged there's this December 16th written letter from Cole, Stoker, and Toski, that law firm, that was discussed in the closed session, but it is entirely exempt under the FOIA due to attorney-client privilege exemption. Well, under the duty to separate exempt and non-exempt information that the FOIA imposes upon them, if their attorney is giving them advice throughout the entire body of the letter, then black all that out, redact it, excise it, and give me the letterhead, the date, and the signature of the attorney. But the FOIA, in that duty to separate the exempt and non-exempt, would not allow them to excise factual information within that legal memorandum. Only the portion where the attorney says, okay, Tucker is threatening to sue you, this happened on this date, this happened on this, that's all factual information. Where the attorney would write, I'm advising you to do such and such. That they could black out. But they have to provide me the non-exempt portion of that letter. And not only, you know, was there that letter, but subsequently on December 16th, you know, I filed, it was February 16th. I filed my Open Meeting Act FOIA lawsuit on February 1st. And on February 16th, David Tucker files in federal court his federal lawsuit, and attached to that are exhibits that not only the federal lawsuit and that draft would have been subject to my FOIA request, but all the exhibits to that would have been subject to my FOIA request. And they failed in their duty to even itemize that those were records that would be subject to my FOIA request that they were withholding. They're not even acknowledging they exist.
They exist. We only have a few minutes left, Eric. I mean, we could go another half hour or more, I'm sure, on this. But ultimately, you know, you have filed this suit. Tucker himself has also now filed that suit. And there was something that was amusing to both of us in terms of the sheriff acknowledging to the Record Eagle something about that closed meeting itself that has now caused yet another problem within the ranks of the county.
And if you go back to the article, this one on February 25th, oh, that's today's.
Yep, last
Friday, February 19th. There's an article about Tucker filing his suit on the 16th, and another one about my discussing filing a amended complaint, which I intend to do with my attorneys. We're reviewing that right now. But the reason why I'm interviewed about that is because, lo and behold, these documents come out, and you know, they obviously went into closed session, and the sheriff reveals on that February 19th article that they went into this closed session. He acknowledged that to the Record Eagle to discuss a threat of litigation, and it was from David Tucker, related to David Tucker's lawsuit.
Which as I understand, and I think as you understand it, is what they should have put in the public agenda to say why they went into closed session in the first place.
Not necessarily their agenda, but in their actual open meeting minutes. They have to reflect the purpose or the purposes.
Why they go into closed session.
Yeah, before they go into closed session, it has to be in our open meeting minutes, and they didn't do that.
So they didn't do that, but the sheriff then subsequently acknowledges to the Record Eagle that's why they did that.
Correct, and the sheriff was in the closed session on December 22nd.
And now that he's done that, the commissioners, some of them, I don't know what the final vote was, but at least the majority of them were concerned about that.
Yes, on Tuesday of this week, I actually went to that meeting and I gave a public comment basically at the beginning of the meeting, and I was discussing the article the sheriff disclosed it. I'm like, he did what you should have done in your minutes of your open meeting before he went into that December 22nd closed session.
Yep.
And he just revealed what you should have revealed initially. So later on in that meeting, I was in court with Mr. Williams. We were dealing with some other matters, but it got brought to my attention after I left the courthouse that the Board of Commissioners had voted to hire one of their attorneys, Richard Figuera, to investigate the sheriff and whether or not he violated Michigan's Open Meetings Act by disclosing the confidential information that was discussed in the closed session. And that's a ludicrous argument, in my humble opinion, because
on its face it seems to be to me too.
It's not confidential information. If he went in there and said, "Yeah, our attorney gave us this advice during our closed session," that's completely different than him saying the general nature of what the topic of discussion was in closed session, which, in my opinion, they should have absolutely revealed in their open meeting minutes prior to that closed session.
So, to sum that up, the commissioners are now hiring an attorney, one of their attorneys, to investigate the sheriff for disclosing the topic of that meeting, which was the whole point of part of the point of your FOIA in the first place.
Correct. And I think one last thing I really need to emphasize is that this law firm, Cole, Stoker, and Toski, have been representing the sheriff in the grievance issue, and they're also representing the county throughout this procedure. Going back to when Tucker initially filed his grievance, I think in April of 2015, going on a year, that law firm has been representing two adverse parties, okay, the county and the sheriff. The sheriff doesn't want to settle a grievance. The county wants to settle a grievance. And they ultimately don't settle it, but yet that conflict, that inherent and absolute, it's not even a perceived conflict, it's an actual conflict. So all these legal opinions that the county has been receiving from these attorneys, it's these attorneys' duty to give them an opinion. First of all, tell them there may be this perceived conflict or there may be this actual conflict with us representing you both in this fiasco, okay? The attorneys have a duty to do that. They never have. And by doing that, I think that they've detrimentally harmed the county's position and even the sheriff's position by not disclosing that conflict and by not saying, look, the county either needs another law firm or the sheriff needs another law firm, because we are polar opposite legal positions with regards to these issues.
I'd love to bring you back again as this progresses, so tell me what's next on the calendar for this.
Well, what's next is my attorney, Frederick Signilson, he is reviewing today the amended complaint, which, in addition to what we've already discussed, I've been meticulously going through all these HR committee meetings minutes, and I'm finding that the committee is a 3-member committee, and some of these minutes, they have a 4th member of the full Board of Commissioners attending these committee meetings and deliberating with them during these committee meetings. So my lawsuit's also going to be amended to include allegations that they improperly conducted meetings of a quorum of the full board because they have 7 members, and when 4 members show up at a committee meeting, it's not properly noticed as a full board meeting that a quorum is going to be deliberating and potentially making decisions on public policy. And because of that, those are other additional counts that are going to be added to my lawsuit. And this all stemmed from, I never would have even read these minutes of the HR committee if they wouldn't have held this closed session on December 22nd. So going back and reading through those things and nitpicking them apart like I do, I just don't understand how they don't know that. How do you not know if you're a board member and you show up and you're deliberating at a committee meeting that makes you a quorum of the full board? It seems to me that's like grade school Open Meeting Act information, 101.
Well, next time you're back, I want to talk about Open Meetings Act and what it takes, to file a FOIA. I'm sure you've spent more than $1 or $2 trying to get all of this information, and obviously with your legal counsel as well. But obviously, there's also going to be more to follow up on with the lawsuits, both yours and David Tucker's. So, thank you so much for coming in.
Sure, and ultimately, the Board of Commissioners is going to be on the hook for all my attorney fees, all my court costs, and punitive damages up to $1,000 for each instance that they were found to be arbitrary and capricious in response to my FOIA request. And it's unnecessary, and it's needless.
Eric VanDussen, Benzie County resident and a freelance journalist, getting himself on the front page of the Record Eagle. Again, today's issue, Thursday, February 25th, and also I'm sure you can get those online from last Friday, the 19th as well. Eric, thank you, sir. Good to have you in.
You too.
Thanks for tuning into the briefing room. I'm Bill Froehlich, and we'll see you next week right back here.